rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are here for oral argument in cause number CV18 0446 Horatio Harianto, and I'm probably mispronouncing that, et al. Versus State of Arizona. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs. We've conferenced this case. We are familiar with the facts. At this point, counsel, you may proceed.
Thanks. Good morning. May it please the court. John Leader for the Harianto appellants, and I'm not going to try to pronounce all the names because I have difficulty with that as well, Your Honor. I'd like to reserve 2 minutes for rebuttal, and I'll keep an eye on the clock, as the court indicated. May it please the court, counsel. There's 3 issues that I'd like to focus on. The first one is going to be the 911 call handler negligence claim. The second issue I'd like to address is the gross negligence claim related to Officer Schmidt. And the third claim I'd like to address is the ADOT negligence claim on which the trial court erroneously granted the state immunity. As to the 911 call handler negligence claim, I believe it's clear under the Division 1 Hutcherson case, which was not reversed in the Supreme Court case, that there is no qualified immunity for 911 call handler negligence claims. We timely disclosed that claim. We asserted that claim. We even did a motion for reconsideration with the trial court when he incorrectly applied qualified immunity to that claim, pointing out the Hutcherson case, which plainly says there is no qualified immunity for 911 call handler.
Counsel,
Sir.
And I know we describe these cases in parentheticals as they vacated on other grounds, but really, is a decision's been vacated? Does it have any precedential with that?
The decision wasn't actually vacated, Your Honor. The Court of Appeals reversed the jury verdict only on apportionment, and the Supreme Court overturned the Court of Appeals and reinstated the trial court verdict in all respects. And if you look at the citation for the Division 1 opinion, it indicates that review was granted in part, and the only part on which review was granted was the fault apportionment issue. So, and by finding that the city was negligent in Hutcherson, I believe the Supreme Court, at least implicitly and arguably explicitly, affirmed the result in the language below. Review was granted on selected issues, only fault apportionment. I don't think that it can be reasonably argued that the Supreme Court opinion in all respects reverses the, I mean, they could have depublished the Division 1 opinion. They didn't do that. They left the Division 1 opinion in place. So it's a fair question.
It's an interesting issue.
It is interesting, but many times you'll see situations when it's more clear that there was an intent to overrule an entire opinion, and I don't think that's a fair read of the Supreme Court opinion here, particularly given that the formal citation for the Division 1 opinion now specifically reflects that review was granted only in part, and that it was not review granted in its entirety. So, presuming that this court's Division 1 opinion remains good law, which I believe it does, I don't see how the trial court's ruling can be upheld. It would be an error of law applying qualified immunity to a 911 call handler negligence claim.
Counsel, how do you reconcile Hutcherson with the Greenfield decision of our court? And I'll be not familiar with that in which our court decided that those who are in charge of record keeping, DPS record keepers, who because of their fault in checking fingerprints that allowed a person to be outside of prison when he should have been in prison, and he went out and killed somebody. So that, and our court found qualified immunity there because it was integrally or they're tied together because they're tied together. The record keeper and the person doing the actual arrest, the DPS officer, it's an integral piece. They work together, and we found that qualified immunity applies. How could you reconcile this situation with the Greenfield decision? Because they're not officers, they're not on the street, they're record keepers. And just like a dispatcher's not out on the street, but they're a very important piece, aren't they not, of relaying the information to the officer out on the road?
They're an important piece, but their role it goes far beyond administrative tasks and record keeping. I mean, they are involved in the calls. They're essentially, to an extent, boots on the ground. And what they're supposed to be doing is they're supposed to be coordinating what the officers who are actually out in the field are doing, but they're essentially the first responders. And in Greenfield, the administrative people didn't have any actual response, to real-time situations, which is the case here. So I think that Greenfield, and I don't know that the parties cited Greenfield, Your Honor, and if
It's actually, we keep saying Greenfield, it's Greenwood.
Sorry.
Greenwood.
Thank you. for the
Thank you.
correction. That didn't
Okay.
sound right when
I
was
didn't
talking.
recognize the name, but I didn't want to look stupid. Anyway, if I believe Greenwood was cited, if the court would like additional briefing, we'd be more than happy to do that. But I think it's just factually different to talk about administrative people who are purely record keepers versus first responders to real-time law enforcement emergencies. I think that's functionally different and different enough that the analysis in Greenwood shouldn't apply here.
But you wouldn't say any policy. What about the policy behind that? Why would you single out dispatchers as opposed to? What would be the policy behind not giving them qualified?
Well, the policy for immunity, Your Honor, is that immunity is a narrow exception, and it's to be applied very judiciously. And so I think the policy is liability and immunity is the exception. So and that's clear from Fidelity Security and a number of other cases. So if you bear that policy in mind, I think you would be required to construe Greenwood narrowly and not apply Greenwood beyond its facts and honor the policy really enunciated by the legislature, which is that immunity is the exception and liability the rule. As to Officer Schmidt, so the trial court concluded as a matter of law, and by the way, one more point, I'm sorry, on the 911 call handler claim. The trial court concluded that the harm occurred before the officers arrived, and I'm sorry, I believe the issue is under Walls whether the harm occurs before or after, and the trial court's ruling on that just doesn't really make sense. I mean, clearly these people were injured before the officers arrived.
Well, I'm glad you brought that up. What does it mean to arrive on the scene?
Well, I mean, I think the scene would have to be where the collision occurred.
But wasn't this a scene for 30 minutes, counsel? I mean, 20, 25 minutes. Didn't you have a scene? You had officers that were going the opposite way, in the northbound lanes, trying to catch the wrong way.
I think that,
driver. How is it not like?
sure.
That seemed to be a very narrow look at what it means to be on the scene.
I mean, in Hutcherson, I believe clearly they defined the scene as where the shooting occurred. And if you apply that analysis here, the scene would have to be where the collision occurred, where the harm occurred. So, Judge, I think it's a very fair.
And under that analysis, I don't see how Greenwood is correctly decided then. I mean, if we accept your premise there that on the scene, and Greenwood, whoever checked the fingerprints was not on the scene. Whoever mistakenly checked those fingerprints and allowed that man to be out of prison. Would you agree with me on that? I mean, so Greenwood, yeah, I don't know. I don't see how you can reconcile that construction of the statute with Greenwood.
Not, in all candor, Judge, not having recently read Greenwood, I don't wish to concede that point. But again, if the court wants additional briefing, I would certainly visit that question.
Can we go back real quick just for the previous point? You guys moved on. When we're talking about Greenwood and you're saying the record keepers versus boots on the ground 911 dispatchers, they're a lot closer to the officer. Wouldn't that give them more reason to have qualified immunity of some sort?
Well, I think you could make that argument, Judge, but it wouldn't affect the underlying policy, which has been longstanding Arizona law, which is that we apply immunity narrowly and liability is the rule. And unless there were, I guess, an equally compelling policy reason that I'm not aware of to apply the immunity statutes more broadly, Again, Fidelity Security in the Fleming case from 2015, Justice Palander wrote the opinion, reiterated that the immunity statutes must be narrowly construed. It's an affirmative defense where the state has the burden of proof, and under the Schabel case, immunity must clearly apply before it can be applied. And that applies not only to absolute immunity, but qualified immunity under 820.02 and affirmative defense immunity under 820.03. And the Glazer case says that. The Supreme Court Glazer decision, it's an affirmative defense, the state bears the burden of proof, and they have to prove that it clearly applies before it does. So it's not just a simple, typical preponderance evaluation of the facts. The state has to prove under Schabel that immunity clearly applies, and the state simply hasn't done that here, even under a generous reading of the Greenwood case, I respectfully submit. We believe that a reasonable jury, and unless the court has additional questions, I'll move on to the gross negligence claim. We believe a reasonable jury could find that Officer Schmidt acted with gross negligence. Walls defines gross negligence, and it's simply aggravated negligence, and it's negligence plus the defendant knowing or the defendant should know that there is a much higher risk of significant harm. And when Schmidt gets the call at 4:23 and the wrong-way driver is still 17 miles away, he was faced with a clear choice. There were two things he needed to do. He needed to accelerate forward, and this is said. Yes, Judge.
Stop. 4:23, what time did the accident occur?
I believe
That was 4:26.
that was the collision. The call to Schmidt occurred at 4:23. Our claim is that he actually should have been called 17 minutes sooner. But
okay.
But the gross negligence claim is based on the fact that when he got the call at 4:23, even though the police report says that he attempted to intercept Haran, which is not true, what he did was he slowed down to 15 or 20 and protected vehicles behind him and himself. But the vehicles directly in front of him were approaching a wrong-way driver. They were at extreme risk, and we believe a reasonable jury could find that it was grossly negligent as to those people, which incidentally included our clients. They were a short distance, if you calculate the times and the known speeds, our clients were a short distance in front of Schmidt when he chose to just slow down, whereas what he should have done is he should have sped up to protect lives in front of him that were savable, then conducted a traffic break at a point where he still would have protected himself.
Isn't it just speculation to know where would that traffic break have been? Where?
Sunset Point, and we presume that Officer Schmidt was familiar with the road. This was his jurisdiction, and I don't believe there's any dispute factually that the appropriate place for a traffic break would have been just south of Sunset Point, and in fact our clients stopped at Sunset Point before the collision. So from a causation standpoint, from a standard of care, or from a negligence standpoint, I don't think there's a real factual dispute that would have been an appropriate place for a traffic break. And from a causation standpoint, had it been done there, it's likely that our clients never would have gotten past the rest stop, never would have made it to milepost 247 where the collision occurred. Officer Schmidt took an oath to protect lives and to save people. I'm a former prosecutor. I have all the respect in the world for law enforcement officers. But he was faced with a choice. There were people in front of him he could have saved, and he made a choice not to do that. We believe a jury could find that that's gross negligence. As to the absolute immunity claim, unless the court has any additional questions on the gross negligence claim, as to the district court's decision to grant absolute immunity to ADOT, again, and we have two main theories in the case. The first theories relate to DPS. The second relates to ADOT's lack of response to a known and very serious wrong-way driving problem in Arizona. And essentially, the trial court concluded that ADOT made decisions that were entitled to immunity, and we don't believe the record supports that. There is no evidence whatsoever that ADOT ever made a conscious decision that what we're doing as to wrong-way driving is enough. From 2004 to 2014, there were between 200 and 300, if I recall the numbers, wrong-way crashes in Arizona. And there's a study from the Illinois Department of Transportation suggesting that Arizona had one of the worst, if not the worst problem in the nation for wrong-way driving. And in that time period, they did nothing. And that is Dr. Blyle's opinion, is that they did nothing and that it's negligent to do nothing in the face of that significant problem. And we believe the evidence is that Dr. Simpson agreed that ADOT did nothing, in that no affirmative steps were taken No additional measures were taken. Nothing was different on the roads. In late 12, maybe 13, I think the evidence is the state began to study the problem with Dr. Simpson. And Dr. Blyle's point was studying wasn't enough. This was a known serious problem that required action.
Let's assume that we agree with you.
Okay.
For argument's sake. How did your client establish a prima facie showing of causation?
Causation, it's based primarily on the result that the state of California obtained. California actually has a wrong-way driving program. They monitor wrong-way crashes, and they have a series of measures they implement to deal with them. California achieved a 75% reduction in wrong-way crashes based on their approach. The problem here, Your Honor, is that ADOT did nothing, and the best example I can think of is the recent hurricane that hit the Carolina coast. Let's say FEMA had arrived there and did nothing, okay? And someone said that was negligent, which it surely would be to do nothing in the face of a serious problem. But addressing causation is difficult when the defendant in question has done nothing. So I think a statistical analysis is appropriate in a situation like that, where you look to what other states have done, again, notably California, and they've obtained great results based on reasonable efforts. So I agree the causation question is difficult, but I think given the unique facts here, there was enough to get it to a jury on causation.
Can you identify any specific reasonable effort that would have helped under these very unique facts, where you have a driver, we don't even know if the driver, we don't know where the driver entered? That
Well, we do.
You know the exact location?
Well, in all likelihood, it was Joe Max Road, because the officers talked to the family, and we know the likely route he had taken, and it was one of two routes, and based on where he was seen on the road, one of those two routes was excluded. So they have a pretty good idea where he got on, and one of the measures Dr. Blyle identified was TAPCO, T-A-P-C-O, it's an acronym, I think, flashing warning signs, which by themselves have been shown to achieve a 30% reduction in wrong-way incursions. And that's just one of a multitude of measures endorsed by AASHTO and the NTSB that Dr. Blyle identified in his affidavit. But I would submit that even the TAPCO signs with a 30% reduction would be adequate to get causation to a jury on a loss of chance theory. So causation is difficult, but I think that there was enough here to get it to a jury. But part of the trial court's basis in granting summary judgment was causation, and the trial court looked at a number of issues, which I'll just submit on the briefs. But what's lacking is an affirmative decision by ADOT. And it's clear under Cole, which is a Supreme Court opinion from 2007, and Galati, there has to be an informed, deliberate policy decision, and there is no evidence of that. And again, if you apply the standards from Fidelity Security and Fleming, which is that immunity must clearly apply before it can be granted, and that liability is the rule, the state did not meet its burden on its affirmative defense to show that it made a decision entitling it to immunity. So if the court has no additional questions, I'll reserve the last 3 minutes for rebuttal.
Thank you, counsel.
May it please the court, counsel. My name is Doug Northup. I represent the state of Arizona. The trial court had several independent and dispositive grounds and reasons for granting summary judgment on which this court should affirm. First and foremost, which is not challenged in this appeal, Judge Hanna ruled that the plaintiffs had not undertaken any effort to determine what standard of care governed DPS or ADOT, standard of care, or breach. That is not even argued and was not raised in argument even here today. That argument is conceded. For the first time in a reply brief on this appeal, counsel suggested that they really didn't need experts. That's a little late for one thing, but it's also wrong. But the court needn't go no further, because a standard of care governing these agencies never was attempted to be established or breached and was not presented on this appeal. Now, an important thing, your honors all know, juries are instructed what lawyers say is not evidence. And it's really an important point here, because there are statements in the brief, there are statements that counsel just made that are not only not in the record, but are demonstrably false. It does you no good for me to stand here and tell you that. But we did put before the trial court, and there the charts 1 through 3 in our appendix, where we listed specifically admitted facts in summary judgment or words from the plaintiff's own witnesses. And that's an important part, because it doesn't matter what I stand up here and tell you or what counsel does. It matters what the evidence in the case was. And for example, counsel said to you, well, it was most likely Haran got on at Joe Max Road. They admitted, this is a quote from the statement of facts, it is unknown how or where Haran began driving the wrong way. That was admitted. The idea that there was a 75% reduction in wrong way fatalities. Dr. Blyle said he had no idea. He had not studied how Arizona's wrong way driver program compared to other states. He said he would have to do that to determine whether there was any standard of care issues. Dr. Blyle testified that he had no idea whether these countermeasures, which Arizona had actually tried some of them, are effective at reducing wrong way drivers. And he said, you know, half of the wrong way drivers start out going the right way, and those countermeasures only apply to a driver who comes the wrong way down an exit ramp. And there are many other ways drivers get going the wrong way. And when he was asked, again, this is in those charts from the record, do you have any reason to suggest that these countermeasures are effective, or that California actually reduced its wrong way driving experience? And he says, no, I don't have any idea. I just read parts of one report. And this Illinois report, Dr. Blyle wasn't familiar with that and never even talked about it. So I think that's really an important point to focus on the effort.
Did any of those studies focus on wrong way drivers who were impaired in some fashion, either cognitive impairment or by substance abuse?
All of them did, because that's the reason almost always that these things happen. And what the conclusions are, and for example, the NTSB report, which Mr. Robinson did refer to, he didn't say it established a standard of care, but it concluded these are difficult problems to deal with. There's not a silver bullet or a right or wrong answer. And the focus really needs to be on trying to prevent those drivers, most of whom are substance impaired, from getting on the road in the first place. Because once you've got somebody in a 4,000-pound missile at highway speeds going the wrong way, that's a pretty difficult job to say to your DPS officers, go get them and stop them. But there have been things that have tried, and in the idea that Arizona did nothing, it was undisputed. It was a specifically admitted fact that Arizona, and Judge Hanna talked about this, that Arizona had undertaken substantial study. They hired Dr. Sarah Simpson they made a determination, we don't want to use the tire shredder devices. Even Dr. Blyle agreed that's not a good idea. They tested TAPCOs. They have, lowered wrong way, do not enter signs at all the exit ramps, which is required by the MUTCD. There's no dispute about any of those things. So the idea that Arizona did nothing is demonstrably false. And in the face of what Dr. Simpson said the state had done, Dr. Blyle said, I don't know what Arizona has done at all. I'm not familiar with whether they've tried any of these countermeasures or anything of the kind, so I don't know. So Dr. Simpson's testimony was unrefuted on that. And again, you can't just say, Dr. Blyle completely changed his testimony. He literally completely changed it in a declaration submitted 3 days before summary judgment argument. And we all know you can't create an issue of fact by doing that. But the real key here is, again, even if you accepted these experts at face value, they say, like Robinson, said, well, initially I had no criticism of Trooper Schmidt, but then he says, well, now that I think about it, he should have sped up and got in front of this driver. That doesn't establish a standard by which a jury could measure anything. That says that a 24-year City of Phoenix police officer who's never had an encounter with a wrong way driver thinks, with the benefit of hindsight, he might have done it differently. That doesn't establish a standard. And in fact, the Bell case that the appellants cite in their reply specifically deals with that. And the court there said only a deviation from a standard constitutes negligence. The jury in the present case could not have found that the hospital's violation of its protocols constituted evidence of negligence unless it first found that the protocols were not merely evidence of the applicable standard, but were synonymous with it. So there, a hospital actually had protocols for administering drugs to a woman who went into labor prematurely, and the court did not allow the jury to be instructed on those protocols because there was no evidence that the protocols reflected a standard. In other words, here, they would have to establish any reasonable DPS trooper would have sped up and then done what he did. Not I think I might have done it differently.
Isn't there quite a difference between medical malpractice cases and other negligent cases?
Not at all, Your Honor.
Because what is the seminal case or the most complaint case we have to say that expert testimony was in fact required here? That there had to be an expert that defines the standard of care?
Well, first, Your Honor, it was never argued, in fact, it was conceded below that expert testimony was necessary. That issue was not even raised until the reply brief. But I want to answer your question. The argument really was, well, the rule only applies if you're suing a licensed professional. A really important point here is Arizona Post, state agency, certifies every single police officer. They must be certified and trained. And here, if you look at, for example, the Naki case that Judge Teelborg rendered, he said, you know, the question there is whether or not when the alleged lack of care occurred during professional or business activity, the plaintiff must present expert witness testimony as to the care and competence prevalent in the business or profession, and then applied that to prison operations. And think about it here. If you ask the ordinary juror, just somebody off the street, how do you handle a pursuit? What do you do when you have a wrong-way driver coming at you? What even is a traffic break? How do you implement that? What's a Class C roadblock? How do you implement that? What are the pros and cons? Who are you trying to protect? What are the risks of implementing a Class C roadblock, and what are the benefits of it? You know, the state spends large amounts of money training its police officers to meet this standardized post-certification. And if plaintiffs were right in their belatedly raised argument, you could grab just any citizen off the street, give them a gun and a badge, and put them in a scout car and say, go forth and deal with this. These are specialized concerns. And as Trooper Schmidt testified, no controverting to this, he said, I got the call, I implemented a traffic brake. I want to stop the traffic behind me, get those speeds down, get those people stopped. Look for an appropriate place to set up a Class C roadblock where hopefully I could do it in a way that I can get out of my car, not get myself killed, and try to protect these people behind me. And the notion that he should have, well, it was okay what he did, but he should have gone really, really fast just until he got in front of the Harianto vehicle and then did it. Maybe Mr. Robinson would have done that, but that certainly isn't the standard of care by which any reasonable officer would conduct themselves. And if you think about it, Schmidt's testimony was also undisputed. He came up over Sunset Point and saw a long line of traffic out in front of him. In fact, at 4:27, he was dispatched. This is in the record. At 4:22, he got the call. At 4:27, he called in that he saw what appeared to be an accident out in front of him. There were a lot of cars that were between him, the Harianto van, and the wrong-way driver. Those cars didn't materialize out of nowhere. So the idea that the Hariantos were just right in front of Trooper Schmidt is completely undercut by the evidence in the case. And again, this is something, a juror, if you just turned a juror loose without experts and said, okay, decide whether this trooper acted reasonably. And by the way, it's not just reasonably, it's gross negligence. And in this case, the complaint didn't allege gross negligence. No disclosure statement alleged gross negligence, ever. The reply brief says, well, we raised it in our summary judgment motion. That's a little late. But more compellingly, there's no suggestion, no evidence from which a jury could say that this heightened standard was met. You know, that it was, you know, I knew that it was likely that harm was going to result, and it was almost certain that substantial harm was going to result. This guy was putting his life on the line and doing the best he could do in a really dangerous situation. That's not gross negligence, and a jury would be left to speculate. And the reason why we can't let juries do that, this is an incredibly sympathetic case. There were 3 people killed. There were 3 horrendous injuries. That shouldn't happen to anybody. But when you put that in front of a jury without proper guidance, that's when you end up with aberrational sympathy, passion, prejudice verdicts, and that's why the law says what it says. In terms of the 911 operator, I wrote down, I just looked when counsel was arguing up there, the last words of the Supreme Court opinion are, we vacate the opinion of the Court of Appeals. Not in part, all of the language that counsel wants to rely on I submit that that argument should be disregarded because that case was vacated and carries no precedential value.
Mr. Reader, if his point is correct, which I don't have any reason to disagree with, that review was only granted in part. If review was granted in part, doesn't that seem like a hyper-technical?
Not at
way to
all.
Look at vacated opinions. I did a quick research on Westlaw, and I found over 300, easily over 300 times when our court or Supreme Court has said vacated, cited cases, vacated on other grounds. And the question is, why are we doing that? And I understand there's black letter law that says that vacated opinions have no precedential value. It said that our Supreme Court has said that.
Well, and Judge
But as a
Brown,
practical matter, are we following that rule?
the cases you're relying on, the Supreme Court can say vacated in part, affirmed in part, but that's not what they did. All of the language that counsel wants to rely on about 911 operators aren't covered and on the scene and after arrival, that was in the opinion that was vacated in its entirety. But that's not the end of it, right? The next question, like your Honor said, the Greenwood case. And I wrote down, and I have to say, I thought it was a compelling argument for the state. The 911 operators are boots on the ground. They are essentially the first responders. How in the world can you draw a distinction between the 911 operators who are boots on the ground and essentially the first responders under the Greenwood case, which has been cited many, many times and has never been challenged at all? And as Judge Brown pointed out, that was a case where a technician from DPS failed to correctly process fingerprints, which allowed a person to be released from custody. And they said, you know, the failure to arrest or maintain in custody qualified immunity prong applies. And of course, we all know the courts talk about immunity should be narrowly construed, whatever, but the law is the law, and this falls clearly in that. Additionally, there was never any allegation ever that the 911 operator acted with gross negligence. There was just a criticism, late criticism, made by Mr. Robinson, but it was undisputed there that the 911 operator called it, they got the call, she immediately dispatched it to Metro Phoenix West. That's where this happened. It starts at 101 and goes north to Yavapai County. Sergeant Sharp was on scene almost immediately. Sergeant Sharp was on the overpass at Anthem when it was called in. The driver just went right under him, and he started trying to parallel and chase him and actually apply techniques that the NTSB report recognizes. He was in pursuit of that person, again, not directly behind him, but in the other lane, trying to interdict him. And even if we wanted to apply the on-scene or not on-scene analysis, this scene was a moving scene. It wasn't where the crash happened. These were officers trying to arrest this particular person and stop him. And even under the Hutcherson analysis, the 911 negligence occurred after Sharp was on the scene. And I think that probably illustrates why that distinction in the Court of Appeals decision really didn't make sense. But even if you want to apply it, the 911 dispatcher met the requirements. And again, there was never any attempt to say the standard of care required that dispatcher to do something differently. And this is another really important point, and that is causation. Because Trooper Schmidt said, if I would have been notified sooner, I would have done exactly what I did. I would have implemented a traffic brake and looked for a place for a Class C roadblock. It is undisputed that the wrong-way driver and the Harianto van were miles ahead of Trooper Schmidt. So if you take their argument to its logical conclusion, Trooper Schmidt would have been farther away from the scene than he was. This was an unfortunate situation. Robinson admitted that only Sharp and Schmidt were the two troopers who were ever in a position to do anything as to this wrong-way driver. It's a tragedy. It's a horrible situation. But to suggest that Trooper Schmidt was negligent, grossly negligent, or a coward is completely inconsistent with the record in this case.
What about causation as regarding
You mean as to the countermeasures?
Yes.
Well, that's a really important point because
How would you respond to Mr. Lieber's argument on that?
I would respond, please look at chart number 2, the Blyle traffic engineering section, because these are Dr. Blyle's own words. He specifically says, I don't know what Arizona did. I don't know what countermeasures Arizona was using. I think that would be helpful to know. He specifically said, I I have not done a comparison as to what Arizona does with anything. And as to your point, Judge Brown, he specifically said when I asked him, what evidence do you have that a countermeasure would have had any effect on this driver who was described as lock arm driving, staring straight ahead, going past cars, blasting past him on the freeway? And he said, I don't have any idea. And he also said, I also don't have any information that would suggest that these countermeasures affect wrong-way drivers or would have affected this wrong-way driver. And think about it. The things that have been tried are these flashing lights. You go on the ramp the wrong way, the lights flash at you and things like that. Well, they're already driving past large do not enter wrong way signs. Again, on causation, he didn't have any idea because he'd done none of these things. And he couldn't tell us, even though his sole measure of expertise as a wrong way driving expert was part of a Caltrans report that he read part of. He said, I have no idea how their program compares to what Arizona did. And the evidence, as we mentioned earlier, that Sarah Simpson said, these are all the things Arizona did. We know if you've been driving at night and you look in your rearview mirror, you'll see all those reflectors in the roadway, they flash red. They have red reflectors on them. Those have been on the highways for years. That's to deal with wrong-way drivers. So instead of seeing yellow or white markers that correspond with the lane lines, you go, wait a minute, something's wrong, everything's red. And all that testimony was undisputed because Blisle said, I don't have any idea. Blisle said, I did not do any analysis to determine whether there was any violation of MUTCD or AASHTO or anything that could be determined to be a standard of care. And again, that's all in the chart number 2. It's all exact word-for-word record sites or admitted facts, and I'm sure your honors have seen that, but that really is an important point. It also does go to the absolute immunity, which obviously is not a necessary ruling for this court to get to. But as to DPS, I believe that issue was conceded in the briefing, but as to DPS, the determination of whether or not to adopt a particular policy is absolutely an administrative, exercise of an administrative function at the policy level. I don't think council makes much of an argument to try to argue around that one. As to ADOT, though, again, it was undisputed, all the things that they had done. And if you look at, for example, the Cole case that council cites, there the Supreme Court said the city of Phoenix was absolutely immune for having used a computer program to determine frequencies and where's the best place to put traffic lights. Well, here the state hired an expert and her testimony was uncontradicted. Again, the notion that she said the state did nothing, that is totally inconsistent with the record. And again, if it was a dispute between what she said the state did and what Blisle said the state did, you could have a question of fact, but Blisle said, I have no idea what the state did. So for all of those reasons, the judge's ruling, Judge Hanna's ruling, was very carefully thought out. He allowed all this in. He allowed in additional documents and declarations days before summary judgment. He considered motions for reconsideration. He carefully considered this and had no problem in reaching a conclusion that summary judgment was warranted. I'm happy to answer any additional questions, but we would ask that this court affirm the judgment below in all respects.
Thank you, counsel.
The majority of counsel's arguments were fact-based, which just underscores the fact that summary judgment was inappropriate. And for every fact listed in counsel's cherry-picked chart, there's a correlating fact in the declaration from Dr. Blisle. So we disagree with all of his arguments about Dr. Blisle. We believe that all the elements are there. As to standard of care, this is from the Lasley case. In an ordinary negligence action, the, quote, standard of care, close quote, imposed is that of the conduct of a reasonably prudent person under the circumstances. In such cases, to prove breach, it is not necessary for the plaintiff to present evidence to establish the standard of care because the jury can rely on its own experience in determining whether defendant acted with reasonable care under the circumstances. Counsel
but the reasonably prudent person in this circumstance is a law enforcement officer.
True. But, Your Honor, the mere fact that expert testimony might assist the jury doesn't mean that a standard of care is required, as in a medical negligence case. We have experts in premises liability cases. We have experts in auto accident cases. And in those cases, the standard of care need not be proven. It's a concept primarily limited to medical negligence cases, and the state has not cited a single case to this court where a standard of care was required in anything other than a medical negligence case. The Bell case, which they cite, is a medical negligence case.
Doesn't the standard also apply to those individuals who are specially licensed and certified
It can.
and acting in that professional capacity?
It can, and I don't believe that a law enforcement officer would qualify as a professional in the way that, for example, the preliminary expert witness affidavit envisions it. So there's no authority before the court that a standard of care is required in a case against a municipal defendant. There is simply no authority to support that. So, and it's why plaintiff was not required to prove standard of care. We were required to prove unreasonable conduct, and from day one, our experts have opined that the conduct in this case was unreasonable. As to Hutcherson, review was granted as to limited issues, and I think jurisdictionally the Supreme Court can only vacate on issues that accepted review on. And it's clear that the review was limited, and Judge Brown, I think your comments were right on point. All the time, this court and other courts have citations that say reversed on other grounds. And it happens all the time, and this is one of those situations. The Supreme Court didn't even look at the qualified immunity issue. So what the trial court ruled and what the Court of Appeals ruled are still valid binding precedent in Arizona. So my time is almost up. Does the court have any additional questions? Thank you.
Thank you, counsel. We thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. We are at recess.